When the FBI pivots from a stalled civil case to a tactical criminal raid in less than 3 weeks, you aren't looking at due process. You are witnessing a sovereign liquidation of election assets that has left Fulton County's legal standing in a state of technical insolvency.
Nearly 2 months after the FBI raided election offices in Georgia, the case went before a judge Friday in a key hearing. Fulton County officials are urging a federal judge to force the Justice Department to return 2020 election ballots it seized during the search. Lawyers for the county argue it was a violation of the Fourth Amendment. But the DOJ claims Fulton County is disrupting a federal investigation into irregularities during the 2020 presidential election. And we should note, multiple investigations have found no evidence of widespread fraud in the state that would have impacted the election results. For more on this, I want to bring in CBS News correspondent Skylar Henry. He joins us now from Atlanta. Skylar, good to have you on. So break this down. You were in court. What happened there today?
Yeah, I think it's important to reiterate, too, Tom, that they were overseen by a Republican Secretary of State, Brad Raffensperger, and the Republican governor here in the state of Georgia, Brian Kemp, all of whom saying that the 2020 election results were not only legitimate, but perhaps were the most efficient processes that have happened in the state's history, so much so that they have time and again stood by these results despite the legal challenges from the Trump administration dating back to 2020.
As a certified public accountant focused on forensic verification, I approach this ballot battle like a mandatory audit where the client, the FBI, is accused of cooking up a criminal narrative specifically to bypass the regulatory obstruction of a civil court. The judge is not buying it, refers to U.S. District Judge J.P. Boulet's signaled skepticism that Fulton County has met the demanding Ritchie factor standard required to prove the government acted with callous disregard for their constitutional rights. We are documentation the moment where the audit of 2020 collided with the operational aggression of 2026, revealing a highly compressed timeline that suggests the criminal search warrant was the special purpose vehicle used to expedite access to the very records the DOJ was struggling to obtain through civil channels. The operational trigger for this forensic fallout was the FBI's January 28, 2026 raid on the Fulton County election hub, which resulted in the seizure of roughly 700 boxes of 2020 election materials. From an investigative standpoint, the audit trail provided by the DOJ on May 1, 2026, reveals a timeline that is forensically volatile. January 5th, 2026, 9:03 a.m. Kurt Olson, a White House special government employee and known election skeptic, formally referred a criminal investigation to the FBI. January 5th, 2026, 8:36 p.m. Just hours after that referral, the DOJ Civil Rights Division moved to dismiss its stalled civil lawsuit against Fulton County. January 6, 2026, the FBI opened an assessment based on the Olson referral. January 14, 2026. The assessment was converted to a full criminal investigation. January 22, 2026. Special Agent Hugh Raymond Evans finalized the search warrant affidavit. January 28, 2026. The tactical liquidation was executed. This 23-day sprint to the raid is the primary conflict in the court of Judge Boulet. Fulton County's forensic verdict is that the FBI used debunked theories and omitted hundreds of pages of contrary information to secure a warrant through the back door of the criminal system. In a standard audit, if a managing partner skips the review period because they don't like the preliminary findings, you immediately flag the entire engagement for management override of internal controls. The forensic integrity of the search warrant is now under a microscope. Judge Boulet has ordered the DOJ to answer 3 specific questions, revolving around the referral date, the investigation opening, and the affidavit drafting, while redacting the county's question regarding whether DOJ officials explicitly discussed using the criminal warrant to bypass the civil case delays. During the March 27 evidentiary hearing, Boulet appeared skeptical of the county's claim that the FBI acted with callous disregard, noting that the omissions in Agent Evans' affidavit may not be as egregious as the county contends. The material risk for Fulton County is the Ritchie factor analysis, which requires proof of callous disregard, irreparable harm, and a cognizable need for the property. Judge Boulet has ruled that the law used to seek the return of property is not a tool for extraordinary discovery of government secrets, denying the county's request for internal FBI communications on April 13th. As an auditor, I track the cost of litigation. Fulton County is now hedged against a 2026 primary election on May 19th, while its voter hub remains in a state of FBI receivership. My forensic verdict on the May 5th, 2026 update is that Fulton County is currently operationally insolvent in its fight for the ballots. You cannot audit the auditor if the judge refuses to unredact the intent behind the raid. The timeline of the referral, January 5th, is the physical receipt of coordination, but without proof of a conspiracy to bypass, the judge is unlikely to liquidate the FBI's seizure. The Fulton County ledger remains deep in the red, and the 2020 ballots are currently being held as evidence in an investigation that appears to have been triggered by the very people the county is fighting in the civil arena. I want to hear from you. Is the 23-day timeline between a referral and a raid a material breach of customary protocol, or is it just efficient law enforcement? Should the FBI be allowed to hold the ballots indefinitely while their criminal investigation remains in a pre-indictment state? Let me know in the comments. Your perspective is the only audit that matters when the integrity of your vote and the solvency of the law are sitting on the negotiation table.